20 years after being sworn in as the nation's top justice, John G. Roberts, Jr. visited the Rice University's Baker Institute for Public Policy for a rare public conversation. He reflects on 2 decades leading the Supreme Court, responds to critiques of the judiciary and judges, and discusses how the court is adapting to a rapidly changing world shaped by new technologies. Welcome to Baker Briefing, where we make the news make sense. I'm David Satterfield. Yesterday, we hosted a special program featuring Supreme Court Chief Justice Roberts in conversation with Judge Lee H. Rosenthal of the U.S. District Court for the Southern District of Texas. Today, we're bringing you the full, unedited recording of that discussion. We begin with opening remarks from Amy Dittmar, provost of Rice University.
Well, good morning, everyone. And on behalf of President Reginald DeRoche and myself, welcome to Rice University. It is a pleasure to see so many members of the Rice community, the Baker Roundtable, and the broader Houston community gathered here with us today. We are incredibly grateful to welcome Chief Justice Roberts back to Rice. His visit today carries special meaning because it continues a connection to this university that many on this campus still remember vividly. 13 years ago, Chief Justice Roberts joined us as part of Rice's centennial celebration. That conversation left a very lasting impression. Even today, alumni will approach us about that event as one of the defining intellectual moments of their time at Rice. It is therefore both a privilege and a pleasure to welcome the Chief Justice back to Houston, especially at this moment in his service. Last September marked 20 years since he was sworn in as Chief Justice of the United States. We are also honored to have with us Judge Rosenthal of the District Court of the Southern District of Texas. Judge Rosenthal is an extraordinary public servant and a treasured steward at Rice. Finally, I want to thank the Baker Institute for Public Policy for hosting today's event. Convenings like this are increasingly important, and they reflect both Rice's values and the Institute's core mission, bringing together students, scholars, and the public to engage in thoughtful, respectful dialogue on the issues shaping our society. Today's conversation offers exactly that opportunity. And now it is my pleasure to invite the director of the Baker Institute, Ambassador David Satterfield, to the podium.
Thank you, Amy, and welcome to all of you. It is my distinct pleasure and privilege to be able to introduce to all of you the Chief Justice of the Supreme Court, John Roberts, and Judge Lee Rosenthal of Texas. Could you please come out? Secretary Baker, Mr. Chief Justice, Judge Rosenthal, welcome. Thank all of you for joining us today. Now, occasions to host a sitting Chief Justice of the United States are rare, and on behalf of the Baker Institute for Public Policy, we are deeply honored to welcome you. Your previous visit here in 2012 for the centennial of Rice University is still very, very much remembered and well recalled. The position of Chief Justice occupies a unique place in our constitutional system. It is, of course, the presiding role in the Supreme Court, but it is also something less formally defined and more demanding. Steward of the court as an institution, guardian of the judicial system in our federal government, and protector not only of the decisions taken by the court, but the court's credibility as one of the 3 branches of our system of government. Now, that responsibility, Mr. Chief Justice, has rarely been simple. It is certainly not an easy charge today. While criticism of judicial decisions, including those taken by the Supreme Court, are not unknown in our history, Andrew Jackson's oft quoted challenge to Chief Justice John Marshall, "Now let him enforce it," is likely apocryphal, but it did accurately capture President Jackson's view of the court. Abraham Lincoln effectively ignored an 1861 writ from Chief Justice Taney regarding suspension of the writ of habeas corpus. FDR famously railed against the 9 old men on the court who had declared his National Industrial Recovery Act to be unconstitutional, and then went ahead with a proposal to pack the court with those more supportive of his point of view. The current president has not withheld his views on judicial decisions and judges with whose actions he doesn't agree. But this present American moment, one of polarization, questions of, if not loss of confidence in the established institutions of governance, science, civil life, the future of the United States itself, it makes the role of the judiciary and the Supreme Court all the more critical and all the more challenging. Mr. Chief Justice, you have served in your role since 2005. You're now the fourth longest serving Chief Justice in our nation's history. During that time, you have led the court through periods of intense legal and political debate with reputation for steadiness, care, and deep regard for the institution and institutions that you lead. Many people remember a line from your confirmation hearings when you described the role of a judge as that of an umpire, calling balls and strikes. Now, that metaphor spoke to something deeper about your approach to the law: discipline, restraint, and a clear understanding of the role of the court in our constitutional system. Those qualities have defined, sir, your tenure as Chief Justice. You have been a thoughtful voice amidst a storm of social media and political incitement, all too often from the most senior level of the executive branch itself, for the independence of the judiciary and the importance of preserving public trust in the rule of law. You're known as a writer of exceptional clarity. Your opinions are admired not only for their legal reasoning, but the precision of the language in which they are drafted. In constitutional law, where a single phrase can shape doctrine for decades, clarity is not merely style, it is substance. Secretary Baker established the Baker Institute for Public Policy as a center of excellence for nonpartisan, rigorously evidence-based analysis and clearly expressed policy recommendations. In his long and distinguished career that began with the law, he understood, as you do, Mr. Chief Justice, that facts must shape judgments. For today's conversation, we are fortunate to have an equally thoughtful and experienced interlocutor, U.S. District Judge Lee Rosenthal. Since joining the U.S. District Court for the Southern District of Texas in 1992 and serving as Chief Judge from 2016 to 2022, she earned a national reputation for intellectual rigor, fairness, and a deep commitment to the rule of law. Across the federal courts, Judge Rosenthal is described as a judge's judge, widely respected by colleagues and practitioners alike for thoughtful opinions, practical judgment, and leadership on issues of judicial administration and complex litigation. Judge Rosenthal, you have long and meaningful ties to Rice University. You served on the Rice Board of Trustees beginning in 2008, continuing a family connection to the university that stretches back decades. Your mother, Fern Hyman, served as assistant university librarian at the Fondren Library until her retirement in 1999. Your father, Harold Hyman, served as Rice's William P. Hobby Professor of History in the School of Humanities. And your husband, Gary Rosenthal, also served on the Rice President's Advisory Board. That long connection with this great institution, combined with your decades of leadership on the federal bench, make you an ideal partner for today's conversation about the court, the Constitution, and the role of the judiciary in American public life. Judge Rosenthal, Mr. Chief Justice, the floor is yours. Thank you all.
Thank you for those kind remarks for both me and the Chief Justice.
I think we should quit right there. I think it.
Fine with me. I've presided over hundreds of trials. I've sentenced people to long sentences, and I've never been so nervous. Mr. Chief Justice, thank you for being here. This is your second trip to Rice, and we are honored both times. Now, there are 4,000 institutions of higher learning in this country. You've come to Rice twice. Why?
Well, there's an easy answer. 45 years ago, I was working in the legal office in the White House under the Reagan administration. I was the lowest on the sort of flow chart, and at the top was then Mr. Baker, not Secretary Baker. So I got used to doing pretty much what he told me to do. Not on the legal substance, but pretty much what areas to go into, what they wanted legal analysis in. So I got a letter from Secretary Baker a few months ago inviting me to come here. And it ended by saying, "I look forward to your favorable response." Well, he did. And I was still used to saying yes, so I said yes, and happy to be here again.
We are honored by your return visit. Thank you. Now, you've worked at 3 different roles in the Supreme Court. You were a law clerk to then Justice Rehnquist. You were an oral advocate in 39 cases, both as Deputy Solicitor General and then in private practice, and you've been Chief Justice for the 20-plus years. Which job was the best, and which was the easiest?
Well, easiest is pretty easy to answer. When I was a law clerk, I was just a couple years out of law school, 25 years old, and as far as I knew everything. So that was pretty easy. I was clerking for then Justice Rehnquist, and he was a wonderful, wonderful boss. Very accommodating, appreciated where we were in the level of legal learning. But he could be very rigorous. I remember fairly early on, he'd asked me to draft an opinion, which was exciting, and I did. Gave it to him. We sat down and he went over it and said, "This is very good, John, but I think it may be a little long, and pretty much everything you want to say is in the topic sentence of each paragraph. So maybe we could just stick with those." And and I said, "You're supposed to, respond." And I said, "Well, I think there's stuff in there that, is pretty useful." And he said, "Well, all right, why don't you keep the topic sentences and put the rest of that into footnotes?" And I said, "Well, okay." I did that and gave him the draft, and he said, "Now take out the footnotes." So that was, he was a wonderful boss, and became, as he did, I think, to most of his clerks, a very good mentor and friend. So that was the easiest. Now, between arguing in front of the court and serving on the court, that's a close call, to be honest. Arguing, just sort of the way I am, I tended to get very, very nervous.
I'm
And
so glad to hear that.
oh, and that was just naturally. I wasn't, and a good friend who'd done a lot of this before. I thought it was very insightful. He said, "Look, you're arguing in the Supreme Court. These are important issues. You have to appreciate. You just don't have the luxury of being nervous." And I found that to be very, very good advice. But the cases were hard. They were important. Some weren't, some others were. And I found that an ordeal. Back when I was arguing, I think more than today, the justices were really hammering away at the lawyers. It wasn't, get up there and give a speech. You'd begin, and almost always Justice O'Connor would interrupt right away. You had basically time for 2 sentences, and she would interrupt, and it was always the core of the case where the rubber really hit the road. So you had to be prepared for that, and then it was just a free-for-all. It was absolutely exhausting at the end, and I just couldn't wait to get back up there. It was I really enjoyed that, but it was hard. And now, obviously,
my current position, it's hard too, but certainly in that environment, it's a lot easier to ask questions than to answer them. The idea that there's no such thing as a stupid question is not really accurate. But it is easier. But then you shift gears, and it's in having to sit down with colleagues and thrash through the issues, and try to decide what are always difficult issues. So the first part, I would say, is more difficult, but the second part is more difficult, and I just feel very lucky to have had the opportunity to do both.
You were originally nominated to replace Justice O'Connor, but then your hearings are about to start, which must have been somewhat a stressful period to start with. Chief Justice Rehnquist sadly passed away, and you were suddenly nominated to replace him.
Right.
What was that like?
Well, the beginning, it was very emotionally draining. You're right. It was a level of tension. I mean, if I get nervous before arguing, you can imagine what it was like to get nervous before those hearings. Chief Justice Rehnquist had been very much a mentor to me, and it was Saturday night, and I'd gone to bed. I was trying to get rested up. My wife called to tell me that the chief had passed away. And then the next morning, I got a call from the White House, and they wanted me to come in, and had another interview with President Bush that afternoon. And then the next morning, they announced my nomination to be chief. The day after that, I'm helping carry Chief Justice Rehnquist's casket up to the Lion Repose at the court. And the new hearings are starting the next week. There's just an awful lot going on, and I had to start learning a little bit more about the chief justices and their role, because that obviously hadn't been a focus. And I do remember thinking, everything was looking pretty good with the first nomination. I was wondering if it made sense to go switch it, but the time went very quickly, and still looking back on it, I do remember the short time from his passing to carrying the casket up, and it was a very emotional time. But you're right, you had to shift gears. I would get a lot of questions on the new position that I hadn't prepared for.
And how did you prepare? How did you learn to do this new job that was suddenly yours?
Well, I don't mean to be melodramatic, but it
Go ahead.
one, I didn't really have much time to do it, and fortunately that went through. And it was really the second day that I was in the court, and we have two conference rooms. In the east one, they have on the walls the first 8 chief justices. In the next one, they have the next 8 chief justices. Just on the side, I don't see where the room is for the 17th, but and I just sort of walked around it, and you look up, and there's John Jay, and I knew about him. In the next one, there's a picture of somebody who I had no idea who it was, and this is the second chief justice. Turned out to be a fellow named John Rutledge, who had he was there for 5 months, so I felt, well, that's not as bad. And then the next one, and not really, Oliver Ellsworth rings a bell vaguely, and then John Marshall. I could talk for hours about that. He's the most significant person in our political history who wasn't a president, and a lot more significant than many of the presidents. And then, of course, Roger Taney, the unfortunate counterpart to Marshall. Okay, I know them. The next one I knew had worked with Lincoln, but I couldn't quite place the name. Salmon Chase was there for a while. And then when I have professors in the conference room that were talking about something, I will always ask them, like, who is that? And sometimes nobody knows. And every now and then, once, Morrison Waite turns out to have been a perfectly good chief justice, first one to support the admission of women to the Supreme Court bar. But again, and then the next one, did not know who he was. I knew, as everybody, he looks like Mark Twain. They were contemporaries. They were always getting mixed up. So if I were a senator opposed to my nomination, that would have been something, wouldn't it? Okay, judge, because I was a judge then, Judge Roberts, 16 chief justices, name them. How do you imagine how embarrassing that would be? Then I knew of more in the more modern ones, but I don't know if I would have gotten Edward White. So, so what I did, frankly, I spent the next summer trying to learn as much as I could. And I found it very useful. There's sort of lessons with every one of them. Even Rutledge. I mean, you look at Jay and figure out what's important. He was first, and you get a sense of how important it was at the time. He left to run for governor of New York. Um, um, but he exhibited extraordinary courage. There was France and England were still fighting, and there was a big issue about when were we violating the neutrality laws or not. And so Washington asked, well, John Jay, he's the biggest lawyer. Let's go ask him. And Jay just to Washington, and this is unbelievable. I mean, Washington was a god. And Jay just said, yeah, I'm not going to tell you. I'm not going to tell you because I'm now the head of another branch of government and I'm deciding cases. I'm not your attorney general. I'm not your lawyer. And that was an incredible act of courage. And it set the tone and the sense that, yes, we are separate. We decide cases and they might involve the government. And so we're not going to be in that business. And all the line that I found anyway, particular perspectives from each of the, even Rutledge. I mean, Rutledge was only there 5 months. They gave him a recess appointment, which is temporary until the, Senate comes back. And in the midst of all that, he was leading candidate for it. Jay's treaty was signed, and he hated Jay's treaty. He was a Southern person. There was the South hated it, the North did, and he denounced it in these intemperate terms. And when he got back, I mean, the Federalist Senate was not going to confirm him, so he was only there 5 months. So there's a valuable lesson there too, which is kind of stay in your lane.
In your 2024 year-end report on the judiciary, you wrote that criticism comes with the territory for judges and justices, and that it can be healthy. You've talked about the criticisms that your predecessors encountered. How do you handle criticism of your court or your opinions today?
Well, it does come with the territory. Often, when any of us issue an opinion, there's often a dissent. Usually not, but I mean, the most opinions or more opinions than anything else are unanimous, and that's pretty. You get used to the criticism right away, and it can very much be healthy. We don't believe that we're flawless in any way, and it's important that our decisions are subjected to scrutiny, and they are. The problem sometimes is that the criticism can move from a focus on legal analysis to personalities, and you see from all over. I mean, not just any one political perspective on it. That it's more directed in a personal way, and that frankly can be actually quite dangerous. Judges around the country work very hard to get it right, and if they don't, their opinions are subject to criticism. But personally directed hostility is dangerous, and it's got to stop.
It's very much part of our lives these days, and on behalf of trial judges everywhere, I want to personally thank you, because while we know that you may not always agree with us, we always know that you have our backs, and that means a great deal. So thank you. And I hope it continues. I know it will. So you have worked as an advocate before the court back in your prior life for private clients and for the United States of America. How did those roles differ?
But in significant ways. You know, in the Department of Justice, there's a little corridor. It's circular, and it says, I won't get the quote exactly right, but the United States wins its case whenever justice is done. I have not had a private client that feels that way about their case. And it is a very different thing. Arguing before the court for my country was very important and a great, very fortunate that I had that opportunity. The government lawyers, as you're facing the court, they're on the right-hand side. They're dressed in what's known as a morning coat. The women lawyers are whatever the equivalent is. I always did feel it was moving for me to stand there and say, I speak for my country. It was hard because that's a difficult client. If you take, for example, an environmental case, you're representing EPA, but you're also representing the Army Corps of Engineers, and they're a big polluter. And, so how do you reconcile, that? So it's complicated. And on the other side, you're representing a private client. And there you have somebody or some entity, whatever it is, even a big multinational, they have put their fate, in the case of some private clients, but their well-being sort of in your hands. And that's a different type of satisfaction. And it's when I was on the left-hand side representing a private client that I really came to appreciate what we mean when we talk about the rule of law. Because you're right there. I mean, it's such an unusual opportunity. It doesn't take place in the other branches of government. They're the 9 people who are going to decide on behalf of one of the branches of government what's the rule is going to be. And you're right there, and you have the chance to look them right in the eye and tell them why you should win. It and you have the representative of the government, they're arguing against you. But you think all I have to do is convince 5 of those people that I'm right, and the most powerful force in the world, the government of the United States, is going to recede. That's what the rule of law is all about. And I saw that and felt it more vividly when I was representing private client than I was when I was representing our country.
Sounds like you miss private practice a little bit.
Don't forget the part where I said I was terrified. Preach high. And it's a lot easier to ask questions than answer them.
You were nominated for the D.C. Circuit on your 37th birthday. You never got a hearing. And then the party in power flaked. How did that feel?
Well, I was disappointed. You started getting I wasn't naive about the prospect that things might not work out. But it was a disappointment. You sort of start looking ahead and planning what your life is going to be like. And again, it's a great honor. And I think a great calling to be a federal judge. But in retrospect, 100%, it was one of the best things that ever happened to me. Because that's a young age to take on a life tenure job. You give up a lot of opportunity for other experiences. I'm pretty sure that if I had done that, I wouldn't have ended up where I am now. You do develop something of a track record, and it's not always something that appeals to people. And I went on and was able to do not only private practice, but also other government opportunities. And so it was a disappointment, but it turned out all right.
Well, I became a judge roughly at that age, and now I know why the rest of my life didn't work out. You are right. The extra time is valuable. And here we are. We're about to celebrate our 250th anniversary of the Declaration of Independence. You will play a part in shaping those celebrations, I suspect. What do you think that all of us should be focusing on and celebrating this year?
Courage. I mentioned John Jay and what he did. And we have to remember that every one of those founding fathers that put their name on the bottom there, they would be, I don't think they would be given the privilege of being shot. They would be hung, and all their families' possessions would be gone. That was an extraordinary step. And it's it's a lot of them, and they were prominent, important people to say that this is what we believe, and the words are just compelling. I'm very fortunate to have in my office something called a stone copy of the Declaration. They were the first copies made by a guy named Stone, and they only made enough. It's right. Every governor, senator, the Supreme Court got one. The White House did. And it's in my office because we lost it when the court moved from the basement of the Capitol to the new building in 36. The clerk is there and tells the marshal, "Well, let's put it here." And the marshal says, "Okay, go ahead." And they're looking at each other, and it was nobody could find it. When they did the first full renovation of the court, 2000, I think, they found it behind a bookcase. So I thought, I'm going to keep it in my office. And I do just walk over and read it, and it's in the original print, and it tells you a lot. And it's interesting, what of course, what they're looking at, what they want is life, liberty, and the pursuit of happiness. And I've always understood those as like not three different things. That's describing a way of being. You're alive, you're free to do what you want and pursue your vision of what's going to be happiness for you, and to put their lives on the line to bring that extraordinary gift to the people. I think it really is. Courage is what I think we should be thinking about.
Which takes us back to the question, how do you handle the pressures and the criticisms of your job?
Well, I mean, and I don't mean to be flip about it. You get a lot of criticism from your colleagues. As I said, more opinions are unanimous than anything else. The process of getting to an opinion involves a lot of critique, I would say, rather than criticism. I mean, you hope you get 9, but you really hope you get 5, and that often involves anything you look at. You think, well, that's opinion by so and so. They're contributions from everybody else on the court, and you do your best to respond to those and put them in what you hope can be an opinion for the court in not just form, but in reality. I actually try not to read outside criticism too much, and it's just because you're on to something else, and you don't want to worry too much about. You've done your best, and that's all you can do.
You and your colleagues enjoy, I think is the right word, I hope it is, life tenure. That means that you work with the same people year after year, day after day. It's a pretty small law firm, and nobody seems to be leaving. How do you manage to keep those relationships collegial when you so often disagree, and so publicly?
Uh, One big answer is that our schedule is set up. I, I resist the idea that it's time off, but we're not with each other in Washington in July and August. That makes it easier. Louis Brandeis, good friend of mine, Louis Brandeis, said he could do the 12 months worth of work on the court in 10 months, but he couldn't do it in 12 months. And I think there was a lot of wisdom in that. And, sometimes people get together in the summer, do this and that, whatnot. I think I got the group right, a Four Seasons fan, and my approach is "See You in September." One one of the best songs. But so that helps sort of recharge the batteries. We do things together during the year. We're not as much at each other's throats as you might think, and there is a very special bond, having gone through the same things. I mean, you think of something like a difficult capital case. That takes a toll on everybody, and even whether you're on the same side or not, we've gone through that together, and we sit down at the conference table together, not only in cases like that, but others hard ones, and different areas. And having gone through that sort of experience over and over again, it does create a bond, even if you're going to be going really at it over in the next case. There aren't many people who share that type of experience, not just in capital cases, but others, and it does create a bond. And at heart, I think we have very strong, not only affection, but respect for each other.
Oh, on top of all of the pressures and the pleasures that you've described, you also serve as Chancellor of the Smithsonian Institution.
Yes.
What is that like?
It is the best thing about being the Chief Justice. And it is an extraordinary thing. It's called the Smithsonian because this guy named James Smithson, who was from England, the illegitimate son of the largest landowner in England except for the king, and became quite wealthy. But as you might imagine, not quite. He knew he wasn't going to be the next Earl. And he was an accomplished scientist. There's a mineral, smithsonite, that he discovered. And he didn't give it to us right away. We were like the fourth or fifth, if my nephew so-and-so doesn't have issue by the time he's 30, then it goes to the next one. And then it was left with us. And it was a sizable fortune. And it was for the greater, accumulation and diffusion of knowledge. And he gave it to us. And Andrew Jackson, obviously defeated the British at the Great Battle of New Orleans, said basically, no, we don't need any stinking English money. John Quincy Adams said, well, not so fast. And so we took it. And the first thing they get, the money, it was a big deal getting it to Washington. Somebody said, well, let's have a national university. And the Jacksonians said, just what we expected. You're going to indoctrinate all. So anyway, it became, through that, and is the largest curatorial and research facility in the world. It is an amazing gift. It's still funded in significant part by the income from the Smithson Trust and the rest from the federal government. And it is just, it's an opportunity as the chancellor for me to participate in all of these amazing things, whether it's the oceanographic facility or the planetarium or the African American History Museum or the Air and Space Museum or the Portrait Gallery, all these things. And to be the sort of one person in the room that really doesn't know, what's involved. And it's amazing how much respect these other people, who are the top people in their fields, in philanthropy and all that, they kind of like having a sounding board's not right, but somebody that they feel, here, let me explain it to you. And I find it incredibly rewarding. The zoo, the National Zoo, is part of it. That's probably the most impressive thing, is as the chancellor, you get to see the pandas before anybody else. And particularly when the kids were young, that was pretty cool.
Well, it sounds like you have managed to keep a number of balls in the air. One of the balls that you keep in the air is your role as head of the Judicial Conference of the United States. And this is the policy-making and rule-making body for the federal courts and the courts of appeals all over the country. I was privileged to serve on the conference, and I've seen you at work, and it was a pleasure to watch. You made it look easy, but I know it's not. How do you do that?
Well, that's another example of sort of me staying in my lane. The people involved in that are experts in it. Trial judges like you know more about evidence and admission than I ever did or ever will. And so when you come up with particular provisions and or rules, I understand that reflects all your expertise. And throughout the budget, I mean, it's like everything else. We have to get a certain amount of money from Congress to support our actions, and Congress has been very good, and they are also responding to the particular serious threats that judges, particularly at the trial level, are facing now, and they're being very helpful and responsive in funding. But that's not something where I'm going to do much good. But the other judges are. They serve on a wide variety of committees covering a wide variety of questions. It's a big commitment of their time. And I'm just very grateful for all they do.
That's also one of the most rewarding experiences I've had as a judge, so thank you for that. We've talked about the ways in which the court is viewed. What do you think are the most serious misconceptions about the court today, and how do we respond? And maybe I
Well,
should say courts.
sure. A lot of what we do is of necessity controversial, and as I said, some of the criticism is very healthy, some of it's not. Misperceptions, for example, the idea that the court, since I've been there, has overruled a lot of cases. Um, you look at the statistics. Uh, the Warren Court overruled something like 3.2% of the cases. The Berger Court, surprisingly, perhaps even more, 3.4%. The Rehnquist Court, 2 point something percent. And what they call the Roberts Court, fewer. It's 1.9% or something like that. There are different things going on in different times. So as counsel, you can understand, well, yeah, the Warren Court was doing a lot of that and this and that. But I think people have a different view. You hear about the cases that people don't like for one reason or another that are very controversial, and they have certainly the right and privilege, and it is frankly quite welcome if they want to let us know where they disagree. That's fine, and they do. But again, it's something that uh, it's important to keep the facts before you. Their jurisprudence takes different routes and changes, and we get people on our court. I mean, you look at that we're some uniform group. I forget what the number is. Maybe I won't get, but I think that people on the court were appointed by 5 different presidents. Um, that is diverse. I mean, in some places you look at us, we're not very, very diverse. I think we're from 3 different law schools, but that's a diverse perspective. And the other thing, the notion that we carry forward the views of the people that appointed us is absurd. President George W. Bush appointed me 20 years ago. The idea that I'm carrying out his agenda somehow is absurd. The issues here now, today, nobody would have thought those were going to be a big deal 20 years ago. And history is full of examples of presidents appointing people and being really surprised how they turned out, going both ways. Felix Frankfurter turned out to be a lot more conservative than his appointing judge, Justice Brennan, a lot more liberal than his. And there is this experience as soon as you're confirmed. And it's amazing how sharp the difference is. Secret Service people had protected me during the nomination. Once I had been confirmed and taken the oath, it's in the White House. You walk out the door, it's Supreme Court police right there. No more Secret Service. It's Supreme Court police. And you become part of, it seems trite, of a real family. And that family is not going to look kindly on the idea that, well, you're just, carrying out somebody else's views. You've got 8 other views to factor in now. And the justices do that. Certainly, I'll always be grateful for President Bush for appointing me, and I'm sure all my colleagues are grateful there. But the idea that I'm carrying out and they are carrying out some different agenda is, I think, really fallacious.
You've talked about how different the issues you confront are now from when you began. And I couldn't have a conversation like this, I don't think any of us could, without mentioning our 2 new favorite initials, AI. So what effect do you think all of these emerging technologies, many of which we can't even imagine, but we do know that they're coming, how can we plan for the effect that these technological shifts are going to have on the work we do, the questions we face, and how we resolve them?
Well, it is absolutely amazing. When I was a law clerk, um, uh, in 1980, we got the very first word processor in the chambers. The first word processor. it was a giant thing, but we looked at it in utter amazement with what it could do. And then things just, of course, started snowballing since then. Obviously, I'm a dinosaur when it comes to the technology. Um, my children love it. They're 25, and we were going somewhere, and I'm trying to talk to Jack and get some sense about what it is, and he shows me. We have a little dog, Jojo, and you know, we talked about writing it. Not me, the children's book about Jojo visits the court, and so he goes, write a song about a little dog named Jojo who goes to the court where his owner is the Chief Justice. He says, and do it in rap. Like that. I don't know, how do they do that? The song comes out, Jojo, go, the court. And then he says, okay, now do it in country western. Different voice, same sort of thing, I remember, whatever it is. And then, do it as an orchestra. Do it. And I'm just completely befuddled by how that can happen. I mean, it'll obviously have impact, I think, for people out there considering going to law school. They have to realize that it's going to be a different job.
Right.
You're going to normally say, well, go research this and give me this answer. Just ask AI. Now, AI will make mistakes, but so do young lawyers. And I think they're just going to have to, the work will change. And for just one thing that worries me, for example, you can put records in cases into the computer and tell AI who should win, whether it's under the law of Nebraska or law generally. It'll come out and it'll give you an answer based on this record. 68% of the time, the plaintiff will win. Oh. Now, if you're a judge and you get the same sort of case, there's some pressure, isn't there? I want to be right. 68% more likelihood of being right. And then in a month or so, you look and all of a sudden now it's 72%. And it goes on that. And it's sort of, again, it will require a great deal of courage, which I think is an overlooked virtue, a judge to say, well, that may be what AI says, but I think otherwise. Those types of pressures, I think, are going to be there. I think it's going to be really tough for young lawyers. 4 or 5 years out, AI is going to be, a partner is going to come to you and say, I need you to analyze this statute and how it's been treated. If AI is going to give an answer in 3 minutes, it's going to take the young lawyer, who knows, 3 days, more than that. So the job of both young lawyers and partners is going to change. And I think people, and I certainly hope good people, continue to go into law, but they're going to have to be pretty nimble to change in response to those. And the rest of us, I'm certainly not, well, I'm not going to try very hard, but, presumably the young law clerks who come in every year will have a little bit more facility with that than I do.
We hope.
That's what we hope.
So you mentioned clerking. You clerked for 2 legendary judges, Henry Friendly and William Rehnquist. And you have had as clerks now generations
Sure.
of young lawyers. And I suspect that you, like me, count the relationship with your clerks one of the singular perks of the job. What do you tell your clerks now?
Well, I tell them I want that analysis by tomorrow. No, it's a very fortunate thing. I don't, I guess the custom began with Justice Brandeis or wherever. You get these very, very talented, extraordinary young people, often have done something else with service in the military or other things. I look for a bit, but you have the luxury of being completely arbitrary. Okay, I haven't had a clerk from wherever, so let's try that. I haven't had a clerk with that type of a background. Let's try that. And they work very, very hard and intensely for a year. I feel I have to be very careful not to rely too much on them, as it can be too easy. So I often have them sort of looking at the same thing from different perspectives. And just when they can't take it anymore, the year's over. So, and you get a new batch with new different perspectives about what's going on in the law schools and other places. And over time, you develop a community of people who have had a close relationship with you throughout the profession. So there are, group of people who are 20 years into their practice, who I have this very close, and almost always, I do a good job picking the clerks, uh, uh, relationship with, and they will keep me apprised. This is what's going on in practice, or people who are teaching. This is what's going on in the law schools, and we have a reunion every year, and it's just a lot of fun. Part of the reunion is the clerks, as we did as clerks for Justice Rehnquist when we were clerking. They do a little skit about what the year has been like. Sometimes it's funny, sometimes it cuts a little close to,
You've changed the way that the court, or perhaps you not by yourself, but the way in which cases are argued now, the format is different. Different certainly from when you were an advocate
right.
before the court. Why has it changed, and is it better?
COVID. During COVID, we couldn't very well have 9, justices and the advocates on the same screen. So we adopted a practice where each lawyer would have time. Okay, you've got 5 minutes to just tell us what the case is about. Then the next one, then the next one, the next one. Very, very different, but a lot of changes with COVID. And then when it was over, people had different views about what to do. Some people liked this innovation because there weren't all these constant interruptions from their colleagues. Other people liked the old way. So we carefully balanced them by doing both. So now we start out with this kind of rough and tumble way of doing it. But then at the end we say, okay, now go down the line, Justice so-and-so, and we need to do a better job of putting a time limit on that, because what's happened is that the time for argument has ballooned, often to sort of like 2 hours instead of the usual 1 hour. And yeah, I think it's a work in progress. But it was because of the COVID experience that people said, we want to do that, but not all that. So we're doing a little too much. Now, my experience growing up, frankly, was with the sort of rough and tumble all along, and I enjoy that. And I'm getting used to the other way, and we'll talk about it from time to time.
I like the way you describe your experience growing up, which implies that we have reached full adulthood. I hope that's right. So you have spent a considerable amount of time, it sounds like, studying chief justices who preceded you. Are there any who you feel are really underappreciated? And how are you going to avoid being in that category?
I was just going to say, present company accepted, but I do. William Howard Taft. I don't know. In my ignorance, had this image, because he was just so fat, that he was and in the plutocratic age, just sort of some fat plutocrat. He was probably the most extraordinary public servant this country has ever had. And because of that, as Chief Justice, he really looked at the court and the courts more generally and said, this could be done better. And he established conference committees, streamlined gave us the cert process as a general. There are courts like in different countries in South America and in India, they have a backlog of 50,000 cases. Now, that's part of the reason that those courts don't occupy a significant role in the government. And so he got us the power to decide what cases we're going to hear, which gave us an extraordinary boost in terms of the prospect of us having fulfilled our role. He's great for that. Other things like that. And he gave us the building. It is, I'm biased, of course, it is the most beautiful building in Washington. If you're there, you should come in. You should certainly come in for an argument. It would not have been done if it weren't a former president saying, this is what we have to do. I mean, his contribution was so significant, and the cornerstone of that building is a photograph of him. He died before the chance to move into it. And people think, oh, okay, you got cases and all that, and I've got this beautiful building. What's the big building? And sort of what followed fairly closely after the opening of the building was FDR's court packing plant. And maybe I'm just too concerned with some appearances, but I think the ability of the court to resist that challenge to its role under the Constitution would have been hampered if we were in the basement of the Capitol. Really, we're an equal branch of government. We're in the basement. And we're spending all our time deciding thousands and thousands of cases rather than focusing on the ones that are important. So I credit him with a big part of saving the court. The other one is Charles Evans Hughes. Should have been president, according to him and other historians. He just sort of ignored California at the time. The votes came in not the way he thought they would. He went to bed thinking he was president, and a reporter called his office and said, I'd like to speak to the president. And the secretary said, Governor Hughes or whatever, and said, the secretary said, that's President Hughes. Well, he said, wake him up and tell him he's not. So then he ends up on the court, and he's the one that's there during the court packing plant. FDR's on the radio that was his evidence, saying the courts did their old, 9 old men and blah blah blah, and we need better to help with the overflowing docket. And Hughes, as you said, he'd been the presidential candidate. Everybody was telling him, you get on the radio and you explain to FDR how this would undermine the rule of law. He was savvy enough to think, no, FDR's, as he said, the people are behind me. And so he realized that would have been a disaster. Instead, he's working behind the scenes, explaining to people what this would do to the role of the court, to the point that and I actually gave a talk about this, looked at through political cartoons. It starts out, the 9 old men, it's sort of this beaten down donkey, and the justices trying to ride on it, and they can't do anything. But over time, as people began to realize what this meant, the cartoons changed. And there's one, the bench of the Supreme Court with 9 FDRs sitting on it. And people began to realize, and if Hughes had taken the other position, again, I think that may not have come out the right way.
Oh, it's hard when you're in the moment to identify those kinds of consequential points. But I suspect that you have lived through a number of them.
Well, I don't know about that, but they do come up. And I have to say, you do feel a little bit of challenged in terms of the range of issues that do come up. And that's why I feel very fortunate to have 8 colleagues that I can turn to, whether to sort of just sit down and thrash them out or more formally.
I live, and I'm very fortunate to have my job. I'm every day grateful, but that building in downtown Houston, which is the ugliest courthouse in the federal system, truly.
I'll get right on it.
And taking every case that comes through the transom, because that's the job. They're very different jobs, but they are the same job. And I know you share the sense of gratitude for being able to discharge it.
Right.
Even in challenging times. We talked a little about your year-end message report, which every district judge and Court of Appeals judge in the country, January 1st, we are at our computers. We are waiting to see what you're going to say. But in your most recent report, and this is a question that comes from a faculty member at Rice, you reflected on Thomas Paine's common sense and the coming 250th celebration of the Declaration. Oh, how should a judge, whether it's at your level or at mine, tasked with interpreting the Constitution, view the aspirational ideals of the Declaration when they appear to be in tension with, or perhaps even in conflict with, the strict legal text or historical practice? What do you do with that?
Well, I mean, the Declaration is it's a sacred document, a charter of what we as a people should try, I think, obviously different views, and obviously a product of its times. Thomas Jefferson wasn't thinking of all the people when he, was writing um, um, the Declaration, but it's not law. The Constitution is the law, and I'm looking forward to the celebration of the 250th anniversary of the Constitution coming up in a little while. But the aspirations in there, I think, are reflected in the Constitution, the separation of powers that it's spread out there. That's what the framers wanted to give life to the aspirations of the Declaration and make sure that carried forward. Again, I think it's what I think we should celebrate on the 4th of July. The courage of the people who brought that into being, and then embarked on defending it, bringing it to reality. It's a great debt we share. And as judges, we're interpreting the laws in the Constitution, but those are animated by the Declaration and the requirement in the Declaration, again, for us lawyers and judges, going back to John Jay, of the courage to live up to it.
One of the things that I'm going to give you to take away as a souvenir of your visit to Rice is a book written by my father when he was in the history department here. It's a biography of Salmon P. Chase, who exemplified perhaps the courage that you've been speaking of as Chief Justice during Reconstruction,
Right.
without the Lincoln who had appointed him,
Mm-hmm.
and the struggles that he faced. You're right, it is courage. Last question. There's a wonderful book written by another historian called Fears of the Setting Sun. It's a book that's based on a chair that was in Independence Hall during the creation of the Constitution.
Mm-hmm.
And it was, on the back of the chair was a painting, wooden chair, of a sun halfway above the horizon. And the question was, is it rising or is it setting? And the book is about the fears of the founding fathers, about this republic that they were creating. And they all had different fears. But my question to you is, rising or setting?
Well, from my perspective, it is rising because of the commitment I see, not only on the court, but in the trial judges, where the rubber really does hit the road. The faith of so many people in our institutions, of course, certainly subject to criticism, but I think they emerge from a lot of the criticism stronger. The separation of powers, which the framers, in a stroke of brilliance, realized was important to keep power under control by having yipped branches separate each other. There are always difficulties. They're going to change. That document has proven durable over almost 2 centuries, and I think it's going to continue for many more.
And on that note, ladies and gentlemen, please join me in thanking the Chief Justice of the United States.
Thank you. Thank you very much.
This has been Baker Briefing, where we make the news make sense. The podcast is brought to you by Rice University's Baker Institute, which delivers nonpartisan policy research on the most pressing issues facing the United States, Texas, and the world. Share your feedback and your guest or topic suggestions at bakerbriefing@rice.edu. This episode was produced by Shannon Moriarty with AV support from Kevin Young. Additional production support was provided by Leslie Marie Aguilar and Ed Bailey. Listen to our other podcasts and find our latest research and events at bakerinstitute.org. Thanks for joining us.